Good afternoon, everyone. As we are nearing to the end of this year 2025, so I felt it makes sense for us to look back at what are some of the landmark rulings the Supreme Court had provided us during this last 1 year, which is technically the jurisprudence which was built under IBC. So obviously there might be a few orders which are not in this list, which in your opinion might still be certain landmark rulings. I'd be more than happy if any of you would like to volunteer to add to this list. But considering the time within which we need to discuss on the session, so I boiled it down to 10 major judgments which I felt have shaped certain key interpretation issues as part of our discussions. So, without any delay, I'd like to step into these rulings one by one. So, the structure of this presentation will be in a manner that we will start off with each order. There will be a brief glimpse of the order on the screen, but I would be taking you through the brief facts of the case and what happened in the matter, and of course, what was the final conclusion, and why is it that it is a relevant order for us to know as part of the IBC framework. So, with this brief intro, I'd like to move into our presentation. So these are the 10 orders which I would be covering during a discussion today. And at the end of the session, I will be sharing the presentation along with the links to all the 10 orders so that anyone interested to know more about the cases can run through. Yeah. So the first matter is in the matter of Independent Sugar Corporation Limited versus Girish Sriram Juneja. Now, this issue, or rather the crux of this matter was majorly on the question of timing of approval of CCI for a combination proposed in a resolution plan. So to give a brief idea about this, we need to look into one key provision under the IBC. So under IBC, under section 31, to be precise, there is a requirement for the resolution applicant to obtain approval of competition authority, which is the CCI, whenever there is any combination involved. So I'll read that relevant provision from the IBC. It says where a resolution plan contains a provision for combination as referred to in section 5 of the Competition Act, the RA shall obtain the approval of the CCI prior to the approval of such resolution plan by the Committee of Creditors. So the term prior to the approval of resolution plan by the Committee of Creditors was the subject matter of discussion in this particular case. So what happened in this case was that, fundamentally, till this particular judgment has been passed, which is in the matter of, so here the CD is not Independent Sugars, so I'll just give the name of the CD. So the name of the CD is Hindustan National Glass and Industries Limited. So this is the corporate debtor. And in this particular case, the question of when do we need the CCI approval has been clarified. So in fact, prior to this, in the matter of Uttam entities, there was a clarification that a CCI approval can also be sought. In fact, it was clarified by the NCLAT. When I say clarification, I mean a judgment or order. So there was an NCLAT order stating that even after a plan is approved by the COC and before the plan is approved by the NCLT, if the RA is able to get approval from the CCI, that should be a sufficient approval is what was the law. So that was the whole reason. I believe that in this particular case also, the CCI approval has been taken at a later stage. But unfortunately, what happened, even though a green channel, again, just to give you what's a green channel, is that the Competition Commission of India has introduced something called as a green channel for speedy approvals, wherein particularly for cases involving insolvent companies under IBC, if you apply under green channel, if you're eligible for application under green channel, and if you apply under green channel, the application under green channel itself is deemed kind of an approval. So it is like a very extremely speedy mechanism for the purposes of approvals of combinations under Competition Act. So that's why CCA, and in fact, we were fortunate to do one CCA approval in another matter. So we have frequently interacted with the CCA officials in that particular case. So they, I mean, the fee involved is extremely high, right? Around 20 lakh rupees was the fee involved for each application. So just imagine, just to give you a idea of what is the major issue in this is that, let's say, in a company, you have got 5 resolution applicants, and all the 5 resolution applicants, upon combination, that is, upon acquisition of the company, they may meet the limits of combination under Section 5 of the Competition Act. So, in such a case, if each of the PRA has to go to the CCI and get a prior approval, it means every PRA is investing 20 lakh rupees for the application before Competition Commission of India for its approval of the combination without knowing the outcome, right? So it may so happen that they may actually not be the successful bidder. So in which case, this entire 20 lakhs is going to be a futile cost for the resolution applicants. But unfortunately, I mean, again, no, I mean, I understand that it's a Supreme Court order, but practically it is kind of a difficult situation for commercially for all the PRAs whosoever are participating in this kind of procedures. So more or less, few PRAs who may be willing to take a bet by filing a plan, they may still back out because they may feel that the 20 lakhs is going for no use. So that kind of a situation might arise. But any which way, so the effect of this order is that it says very clearly that the statutory intent of securing a prior approval from the COC as mandated under Section 31, subsection 4 of the IBC should be upheld. That is the major contention, or rather the major observation made by the Supreme Court, wherein the Supreme Court even went ahead to say that the plan submitted by the PRA should be held unsustainable for the fact that they have not submitted for the fact that they have not got a prior approval from the Competition Commission of India. So that is the major position which has evolved out of this particular judgment. As you can see on the screen, it is a 2:1 judgment, meaning in a bench of 3 judges, one judge had differed from the opinion of others. So that's why there is a difference. I mean, because there one of the judges had has given a separate opinion stating that ideally that need not be made mandatory. But since the majority prevails, so currently the position under this is that any approvals from the CCI should be considered as a prior approval which has to come from the CCI prior to taking approval from the COC. So this is going to be the current position of law as regards the approvals required from the CCI. So we will now move ahead with the next order. So the next Supreme Court order is in the matter of Bhushan Power and Steel Limited. So this case has been in the limelight for many reasons. First and foremost, the order of the Supreme Court in May, which has which literally had damaged, or I would say probably caused a lot of threat to the investment in stressed assets under IBC. The reason I say this needs some digging into the facts of this case. So the facts of this case are that this Bhushan Power and Steel Limited got admitted into CARP in the year 2019. Right, and subsequently, after all the process under the IBC, JSW Steel had emerged as the successful resolution applicant, and the bid amount was a whopping amount of 19,700 crore. Okay, then in 2019 itself, it's like in immediate succession, the plan got approved, and after the plan got approved, okay, after the plan was approved by the COC and before the plan is approved by the NCLT, ED started coming into picture. So ED attached the assets of the corporate debtor, and that is a development which happened after the plan is approved by the COC. So not just think of a resolution applicant who is committing to pay 19,700 crore for acquiring an asset, and then he understands that, or rather he is faced with the fact that ED has come up with an attachment on the same assets for which you have bid for 19,700 crore. All the assets, right? So now, how do you think this will encourage investors like JSW Steel to keep trusting the process of IBC while other government authorities come and attack the assets of the corporate debtor, right? So that's where there was a delay from the side of from the side of JSW in implementing this particular plan, right? Now, as part of that delay, they have invoked one section under the resolution plan which allows them for mutually agreeing to delay the implementation of the plan, rather with the approval of the COC, obviously. So in the monitoring committee, the COC representatives have approved it, and even the RA was part of it. So therefore, they together have filed for extension of timeline for implementation of the plan. So that part is taken care of. Now, after that part has been taken care of for the purpose of delay, finally they came to an understanding that, okay, fine, we will still pay, we'll go ahead and pay you 19,700 crore, but we filed our appeals before the Supreme Court on this. So in the 2 years time between 2019 to 2021, all the parties have they basically went ahead and litigated majority of these issues with respect to ED, and even the promoter of the company had filed certain appeals against these orders, and all this has taken place. So in 21, the creditors and the RA have come to an agreement that let us now come to an understanding that we will implement this plan, but subject to condition that any of this implementation will be subject to the outcome of the appeals before the Supreme Court. If at all there is an adverse order from the Supreme Court, in such a case, all the creditors have to give back the monies to JSW Steel. So this was the understanding with which JSW Steel has implemented the resolution plan. So far, so good. The story actually is a good story, expecting a great climax. But then it went ahead before the Supreme Court, and the Supreme Court, in its first order in May 2nd, 2025. So this is almost after like 6 years of litigation, maybe let's say 5 to 6 years of litigation. Supreme Court comes with an understanding that, boss, as per the resolution plan, you were supposed to implement it within X period, while you delayed it by more than 2 years, even though you paid 19,700 crore, right? So mind you that Supreme Court is well aware of the fact that JSW had went ahead and paid 19,700 crore, and they know that there is a lot of litigation, but Supreme Court states in its order that it doesn't matter, whatever is the plan. I mean, obviously not the same words, but still, it indicates that Supreme Court doesn't care about what litigation is there, nothing. You had committed a particular timeline under the plan, you'd fail to do that, so it's a failure of the resolution plan. So therefore, your plan shall be rejected, and whatever amounts are there, it shall be as per the agreement between JSW Steel and the creditors. So they're fine with the creditors repaying the entire 19,700 crore back to JSW Steel. And in further, they even went ahead to give a direction for liquidation of this particular case. I mean, just imagine a company which is having operations, which has got an excellent resolution amount of 19,700 crore, and for which the operations were continued even after the CARP order has been passed. JSW Steel has been actively taking care of the operations of Bhushan Power and Steel, and they have in fact got good positive EBITDA for all that period after the CARP has concluded. And with all this in mind, still Supreme Court went ahead and ordered for liquidation of this case. That was in May 2025. So after the May 2025 order, there was an immediate review which was filed against this particular order. And luckily, in July, the Supreme Court division bench had recalled its own order, stating that there are blatant issues, like a very evident issues in the order. So they said, we are recalling this order. So in the review petition, they recalled the order, and they said they will be hearing it afresh and passing a new order. Subsequently, after further hearings, on 26th of September, the Supreme Court had went ahead and upheld the JSW Steel's resolution plan of 19,700 crore. Now, a key issue which I'd like to point out in this particular case, particularly in the matter of in the interpretation made by the Supreme Court, is that where a resolution plan contains a clause allowing for extension of timeline, and the timeline for implementation has been extended by invoking the same clause with the permission of the COC, such an extension of implementation timeline cannot be looked at cannot be considered as a contravention of a resolution plan and cannot be a ground for rejection of the resolution plan. This is the crux of the major litigation which has undergone in this particular case. Of course, there are other issues also, like that of COC wanting a share, or rather COC wanting the entire EBIT profits or cash surplus which has come after the plan approval till this date. COC was actually expecting that, or till the date of handover of company to the JSW Steel. But Supreme Court also mentioned that had that been the case, that should have been part of your RFRP. Right? If COC is expecting the excess revenue or the cash surplus or the profits made by the corporate debtor after the approval of resolution plan by the COC till the implementation of resolution plan by the corporate debtor, by the successful resolution applicant, in such a case, the same should have been part of the RFRP was what was the argument, and even Supreme Court says yes. If that was your expectation, that should have been made part of the RFRP. So fundamentally, two important aspects emanate out of this particular judgment. Number one, if COC is expecting recovery or is expecting the excess share of profits which the corporate debtor makes after the COC approval till the implementation of the resolution plan, then COC should make it a point that the RFRP contains that clause. So for all the RPs in this group, including me, wherever we are RPs of a company which is having operations, we should at least initiate this discussion with the COC as to what will happen to the excess surplus which is generated by the company, and what will happen to that money till the time the company is handed over to the resolution applicant. Will that surplus belong to the resolution applicant? Is it one of the ways by which we would attract more resolution applicants to show interest in the company, so that they know that even though there is a delay in implementation, delay in the NCLT passing the order, at least they are assured that whatever revenue they could make during that particular period of delay can still come to them after they implement the plan. That can be your strategy. Or if you feel that no, this rightfully belongs to us because we are the creditors who are suffering loss, so we would need that money as well. So what would be the stand of the COC? I at least prefer it to be carefully captured in the minutes of the meeting, so that the COC will have this. So there's a clarity on that. At a later stage of litigation, at least you can say that this has been discussed. And this is what the COC has decided, and that is the reason why it is not part of the RFRP. So and this is from the RP's point of view. And from the COC's point of view, if any of us are advisors to the COC, we should certainly advise the COC that if they are expecting any surplus to be distributed to the COC, they should very clearly mention that in the RFRP. In addition to EMD, PBG, which are the major requirements for which usually we go to the COC for their comments, I feel this is also a very important discussion which we need to do with the COC with respect to distribution of surplus amount which has been which was generated during the process. So this is all about this particular case of Bhushan Power and Steel CIRP, fundamentally on delay in implementation of the plan. So as I said, two important points which emanate. Number one, COC to take care of the RFRP whenever they are whenever they need the surplus amount to be distributed to the COC with respect to surplus of operations. Point number two is where you see that there is a possibility of a particular delay in implementation of a plan, at least the RA, this is particularly for the resolution applicants or for RPs who advise resolution applicants, always include a clause which would enable you to seek approval of the committee of creditors or the monitoring committee for further extensions in implementation of your plan. So generally, COCs do consider legitimate delays by resolution applicants, considering their timeline, considering their financial whatever at that particular point in time, whatever market conditions prevail, etc. COCs are usually considered enough to consider such kind of delays. But if there is no provision in the resolution plan empowering the monitoring committee or the representations of the COC to allow such an extension, then it would be a futile exercise, right? So therefore, if we are advising a resolution applicant for submission of a plan, we should ensure that the plan contains this clause, which is an enabling clause for seeking extensions in the implementation of the resolution plan, with, of course, with the permission of the committee. Now, see, the clauses should not also be a one-sided clauses. Ideally, it should be a clause which should be in consultation with the creditors, in order for you to take some advantage of this, right? So this is the major issue in this case, and in my view, in this year, this is one landmark ruling which has at least clarified certain issues where the delays are beyond your reasons, and delays are particularly caused by certain government actions. There should be a lenient view taken on the resolution applicant. And just as an add-on, in this case, even today, the issue of PMLA versus IBC is still a debate. The Supreme Court, I mean, even though there are multiple orders on either side of this coin, I mean, before the NCLT and NCLAT, but from the Supreme Court, we still are waiting for a clarity on what should be the position of the ED attachments, particularly when the companies are undergoing CIRP. So because of this, RPs also face a lot of issue in marketing the assets. Resolution applicants face a lot of issue before they submit a resolution plan, considering there is an ED, and the very core idea of value maximization is hit whenever CD's assets are being attached by the ED. So this is the core of the dispute in the case of Bhushan Power and Steel, and it is still pending before the Supreme Court. So even though the Supreme Court allowed the resolution plan as such, but the very fundamental issue of the ED attachment, can such attachment prevail even after the introduction of Section 32A? That is something which is still undecided. So at least in 2026, if we can expect this order, it would be a great relief of certainty for the investors, committee of creditors, even for resolution professionals, whenever they're dealing with assets attached by ED. So with this, I'll be moving forward on the other case. So this is all the discussion on Bhushan Power and Steel Limited. The next landmark ruling is in the matter of Mansi Brar Fernandez versus Shubha Sharma. So this is a case of, again, like after Pioneer, another landmark ruling for home buyers and the protection of their rights is coming under Mansi Brar. So this is a case where there are two home buyers who were themselves experiencing financial distress, and they signed an MOU with the corporate debtor, which is Gayatri Infra Planner Private Limited. And as part of the MOU, so see, ideally in a case of home buyers, what do we see is a sale agreement, right? So either an agreement for sale, and then we will do an allotment. That's the usual structure of agreements which we do in a real estate allotment to home buyers. And of course, even under RERA, that is the basic expectation. However, in this case, they had an MOU. While as part of the MOU, Mansi Brar agreed to purchase 4 flats, for the 4 flats, the consideration was 1,03,78,000, out of which they paid 35 lakh rupees. Now, there was a buyback clause as part of this MOU, whereby the developer committed to buy back this flat at 1 crore within 12 months, right? So, technically speaking, they have, it sounds like an investment agreement wherein 35 lakh rupees has been invested, for which 1 crore return is expected in 12 months, right? And the whitewash of this MOU is as if this 35 lakhs has been provided for acquiring the 4 flats, while that's on the front. But if you see the exact nature, the nature of this agreement is a speculative thing wherein you're rather expecting for a 1 crore buyback by the promoter within a year's time, which is kind of more than 150%, at like almost 185% of return over 35 lakh of rupees which you're investing, which you're going to get it within just 1 year's time. So that was the kind of transaction which was highlighted by highlighted in this case of Mansi Brar, right? And in this case, as I said, the developer entered into CIRP, the Gayatri Infra Planner Private Limited, and basis this, the core issue which has come before the Supreme Court was who will qualify as a financial creditor in this case. Should there be a possession obligation in order for us to conclude that there is conclude the stand that someone should be a financial creditor, or even speculative investors with assured returns, can they still be considered as home buyers, was the question before the Supreme Court. The Supreme Court, of course, like a no-brainer, very clearly said only genuine home buyers with possession obligation, meaning those who have the obligation to get the possession, or rather there should be an obligation on the corporate debtor to give the possession to such home buyers, right? So that is when they should be categorized as a home buyer, or rather as a financial creditor. And then they say that wherever there is a buyback clause, they should ideally not be considered as genuine home buyers, and accordingly they cannot be considered as a creditors in a class as good as any other home buyer. They should not be provided such a treatment. So that's when that was something which was ruled in this particular case. And beyond that, the Supreme Court also went ahead in referring to the cases of even the cases of Pioneer, to wherein this particular situation, I mean this particular fact was also discussed in that case, right? So that was the major issue. And they of course also held the one point that there is, I mean, right to secure fundamental possession of the unit is also one of the fundamental rights, is what has been provided for in this judgment. So this is how the Supreme Court had handled the issue, saying that speculative investors should not ideally misuse the process and frame themselves as home buyers and invoke this particular procedures. So that is how the Supreme Court had dealt with in this particular case of Mansi Brar versus Shubha Sharma. We'll now move forward to the next matter, which is EPC Constructions India Limited versus Matix Fertilizers and Chemicals Limited. So in this case, the core issue was whether cumulative redeemable preference shares, whether they are financial debt or not, whether a holder of cumulative redeemable preference shares can be considered as a financial creditor or not, is the major question which has come in this particular situation. So the facts go back to if the facts in this case are again extremely relevant. So in this case, so EPC Constructions India Limited is the creditor, claiming themselves, of course, as a financial creditor. So the corporate debtor is Matix Fertilizers and Chemicals Limited. So they had a outstanding of around more than 500 crores to be paid to EPC Constructions. And then in 2015, they decided to convert this dues into convertible, into preference shares. So wherein they had non-cumulative redeemable preference shares as the original understanding. And then subsequently, at the time of allotment, they have come up with, of course, after all the negotiations and all, they have agreed for issuance of cumulative redeemable preference shares. Okay. So by which they have agreed for a particular amount, and then tenure, everything has been agreed for. But subsequently, there is a default. And then because there is a default, they have come under this particular question of, they wanted to submit this particular claim as a, they have submitted the Section 7 petition as a financial creditor. So that's where the interpretation, that's where it was litigated, stating that whether this particular amount of redeemable preference shares, that is the compulsory redeemable preference shares, can that be considered as a financial debt, and can that be considered as a financial debt, and can a Section 7 petition be admitted against the company, was the question. So in this case, another interesting aspect is that EPC per se was undergoing CIRP. So it is the liquidator of the EPC constructions company which had initiated this Section 7 petition against Matix Fertilizers and Chemicals Limited. So this is the core fact of the case. So now the major issue before the NCLT was whether this CRPS, that is the cumulative redeemable preference share, is equity or debt, right? So that's a simple question. If it is debt, then you can come under CIRP, you can initiate Section 7 petition, and you can be considered as a financial creditor. But if it is equity, then of course you will lose the right to actually come and initiate a Section 7 petition. So that's where the question was before the Supreme Court. That of course went ahead before the Supreme Court. And if we look back at the history of this case, the NCLT ruled that it is not it's not a debt, it is equity, right? So they say it is an equity investment because cumulative redeemable preference shares are share capital and not debt. Second, even they went ahead to give a justification saying that as per Section 55 of the Companies Act, the redemption of these preference shares are from profits and not unlike debt where these are adjusted against your P&L. The NCLT made an observation that these are derived from profits of the company. So therefore, how can that be considered as a debt, right? And therefore, they say that there is no profits in this company Matix. Thereby, there are no profits. The Matix is suffering losses, meaning there are no profits available. When there are no profits available, there is no debt which is there. So in this case, there is no debt. There is no way you can claim a default, and therefore there you cannot come as a financial creditor, was the view of NCLT. Obviously, it was appealed before the Honorable NCLAT, and the NCLAT went ahead to say, in this case, the CRPS holders, that is the cumulative redeemable preference share holders, are none other than investors, and therefore you cannot consider them as financial creditors, was the view taken in this case, by the Honorable NCLAT as well. And then it landed up before the Supreme Court. So Supreme Court had a detailed discussion of around 50 paragraphs in 42 pages, where they were predominantly looking at the question of, or rather the meaning of, financial debt. So I think for many of us who have this question whenever we are verifying a claim, at times, like when we look at a particular claim, there may come a situation where we are confused whether it is a financial debt or not. Then we have one more judgment to look from, where plethora of rulings, past rulings in multiple cases have been referred, wherein they are trying to come to an important aspect of understanding the meaning of financial debt, and more importantly, under Section 5, subsection 8, right? Of course, the definition. And that's where, in fact, Section 5, subsection 8, clause F is something which is a very generic clause which says there is a commercial effect of borrowing. So that's the case based on which we are. That's the section based on which this is being provided for. So, in the Supreme Court, they went ahead to interpret this particular section, wherein they said that even in order for us to look at whether section 5(8)(f) will apply, we need to first see that it is a debt. So for us, as we have, and they went ahead to say that the fundamental question we are looking at is whether it is a debt or not. And they have an impression, they have, as per their as per their interpretation, as per the Supreme Court's explanation or interpretation of this clause, they have differentiated between, or they have provided a conceptual difference between the terms debt and preference shares. So for which they went ahead, of course, into a lot of jurisprudence which evolved in various publications, including the Gover's publication of Principles of Modern Company Law. They have went ahead to look into all these aspects just to come to a question of whether there is a difference between debt and preference shares. And they have opined that the debt is different from that of the obligation which is created from that of a preference shares, and therefore a holder of a holder of cumulative redeemable preference shares cannot be considered as a financial creditor because there is no debt as such which is created by them. Right. So that is exactly the point which is being provided for in the Supreme Court order. And if I have to read this one important paragraph from Supreme Court order, which says that in order for there to be financial debt, there needs to be disbursal against consideration for time value of money. And then they go on to say that there is no section under section 5(8)(c). So section 5 subsection 8, which defines financial debt, it does not talk of preferential shares, while it talks of note purchase facility, bonds, notes, debentures, loan stock, or any other similar instrument. So with this, they come to a conclusion saying that paid up money on shares being share capital cannot constitute and do not constitute debt. So that is the fundamental point which has come from the Supreme Court's ruling, wherein it says that the paid money on shares being share capital do not constitute debt. So with this, the Supreme Court had concluded that the holders of cumulative redeemable preference shares will not be considered as financial creditors. So now, another interesting interpretation which I found in this order is typically if one has to look at the accounting standards, right? So if one has to understand this liability from that of accounting standards, see, as per the accounting standards, wherever there is a liability admitted, so wherever there is a liability of the company, it has to be obviously reflected as a liability in the books of the company. Now, as per the fundamentals of company law, any equity, rather any share capital, is a liability of the company. It is obviously shown on the liability side. So the appellant had taken an argument that financial debt is a admitted liability in the books of the accounts, wherein Matrix Fertilizers had in fact reflected it as a liability in the books of accounts. Now that's where the corporate debtors councils have countered, saying that entries in the books of account cannot determine the true nature of a transaction, right? So wherein they say that as per accounting standard 32, where in the case of a preference shares which provide for mandatory redemption for a fixed or determinable amount at a future date, in such a case, it will be considered as a financial liability. This is as per AS 32. But in the accounts, due to prescription of accounting standard, whatever treatment has been done cannot determine the exact nature of relationship between the parties is what was the view taken by the senior court, right? So this view was also kind of been seconded by the Supreme Court, wherein Supreme went ahead to observe that IBC has got its own prerequisites in order for the parameters to meet the Section 7 application. Therefore, resorting to the treatment in the book cannot decide this case if what the Supreme Court observation in the matter. So, important findings or important learnings from this case is that number one, if you are a different then you definitely have a very great concern, even if it is not a compulsory conversion, not even a shareholder. If you are eligible for the reduction, but considering that situation of itself, it all they have basic of that it 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 what the so at least there is a concern that it it
Sir, your voice is cracking.
is better.
No, sir, not able to hear. Last 5 minutes.
Yes, sir. You are not audible.
I thought it's my fault and my device, but not audible at all.
Better now.
No, no, no.
Right.
Let me log in again.
Yeah, yeah, I'm doing. Yeah, is it any better?
Yes, sir. Now it's better.
Yeah, thank you so much for highlighting, sir. If I may know, what was the last part you were able to hear clearly, sir? This particular case, should I repeat? This EPC constructions?
Please, sir. Please.
Yeah. Okay. Thank you. So, yeah, just to very quickly give you a recap of this case. So, this is a case where EPC Constructions India Limited was a CRPS holder, a cumulative redeemable preference shareholder, and it had filed a Section 7 petition against Matix Fertilizers and Chemicals Limited. Now, in this case, EPC Constructions was itself undergoing liquidation process, And the liquidator of the EPC Constructions had issued a letter to Matex Fertilizers for redemption of the preference shares, because the preference shares were issued way back in 2015 with a tenure of 3 years, and since they have expired till date, there was no redemption of the preference shares. And then this was issued to Matex, and Matex had denied any liability. So, aggrieved by that, the liquidator of EPC Constructions India Limited had preferred an NCLT or Section 7 application against Matex Fertilizers and Chemicals Limited. So, the fundamental question before them, and also the core issue argued by the corporate debtor, which is Matex Fertilizers and Chemicals Limited, is that whether the cumulative redeemable preference shares as a nature be considered as a financial debt. That is a core issue before the NCLT. The corporate debtor argues that a redeemable preference share cannot be debt, while the EPC Constructions Limited, claiming itself as a financial creditor, argues that they do meet the nature of financial debt. Having convinced that this instrument per se is more of equity than debt, the NCLT ruled that it is not debt. It is in the nature of, it's not equity as such, but it is in the nature of preference shares. It's in the nature of share capital and not debt. Therefore, NCLT ruled that the Section 7 petition cannot be maintained, considering that there is no financial debt. Aggrieved by that, EPC Constructions Limited had moved before the Honorable NCLAT, which also upheld or affirmed the decision of the NCLT, and NCLAT had also opined that the nature of these holders of CRPS are more in the nature of investors than debt holders. So therefore, it cannot be treated as a financial debt, was what was the ruling of Honorable NCLAT as well. Then ultimately, it landed up before the Honorable Supreme Court, wherein the Supreme Court was in a extremely detailed discussion, wherein they were also referring to certain jurisprudence of corporate law in terms of differentiating between the terms of debt and preference share capital. So whether a preference share capital is debt is the fundamental question which the Supreme Court was analyzing. And as part of its analysis, there was one interesting aspect wherein the parties were arguing that as per the accounting standards, wherever a preference share shall be redeemed, and even if it could not be redeemed at the end of the maturity period, it should be classified as a financial liability as per AS 32, was the argument of the financial creditor. The alleged financial creditor. While the corporate debtor argues that a mere accounting treatment cannot decide the nature of a transaction, right? So they go on to say that the accounting standards will not be determinative of the nature of relationship between the parties, which is clearly reflected in the documents executed by the parties, was the argument made by the corporate debtors council. So ultimately, even Supreme Court had bought that argument, had seconded that, very clearly saying that sections under IBC, the IBC has its own prerequisites, which has to be passed in order for Section 7 petition to be considered. So therefore, treatment in the accounts cannot decide the facts of this case, was the view of the Supreme Court. And they went ahead and analyzed various other Supreme Court orders and other jurisprudence available in this particular case. And they came to a conclusion saying that Section 5 subsection 8, which defines or which deals with the financial debt, does not necessarily comment anything about the preferential shares. So it doesn't comment much on, rather it is completely omitted any reference to preference shares. So what they intended to infer from this interpretation is that they say that the Section 5 subsection 8 provides for even instruments like that of note purchase facilities, bonds, debentures, loan stock, or other similar instruments to the such categories, but it does not talk of preference shares. And then here's where the language becomes more interesting. The Supreme Court goes on to say that the omission is significant. So in the Supreme Court's opinion, the omission of any reference to preference shares in the definition of financial debt is a significant omission. Therefore, the the paid up money on shares being share capital do not constitute debt. So the fundamental aspect is paid up money on share capital cannot constitute debt, being therefore meaning that CRPS, even though has debt-like features, it forms part of share capital. It lacks time value element, and there is no classification of preference shares as a financial debt in the definition. And therefore, with all this in mind, the CRPS, the CRPS cannot necessarily be treated as a debt, and accordingly, the NCLAT's order has been upheld by the Supreme Court. So the conclusion of this case is that a cumulative redeemable preference shareholder cannot be classified as a financial creditor, as it cannot be treated as a financial debt. So this is the ruling of Supreme Court in the case of EPC Constructions versus Matix Fertilizers and Chemicals. Now, as we move forward, another interesting case, again a long drawn litigation, luckily did not stay the resolution plan procedures. This is in the case of PRAKUL Capital Housing Finance versus 63 Moons Technologies. And in this case, the interesting aspect, again, just to give an idea of what this case is about. So this is a case where you can recollect the merger of PRAKUL Capital and Housing Finance with that of DHFL. So there was a reverse merger. PRAKUL got merged into DHFL and continued the operations, and they took over basically DHFL. And DHFL was a matter which was a financial service provider for which insolvency was initiated by the Reserve Bank of India, who has appointed the administrator. So the Reserve Bank of India had appointed the administrator, who's not an insolvency professional, who is a RBI authorized person to take up this case. And subsequently, there are, as you all might be aware, there are rules for financial service providers and the regulations as well, which give some level of relaxations and some level of different conditions in terms of how the process has to be held. And at the end, PRAKUL evolved as the successful resolution applicant. But this case was actively being litigated by the Vadhavan group. Of course, the erstwhile promoters who have been actively litigating this case before the NCLT, NCLAT, and finally before the Supreme Court. But out of all this, the two major issues were, number one, of course, challenging the resolution plan by the erstwhile promoter, which we see in all the matters till date. Every time they keep on coming up with something before the Supreme Court. They intend to keep litigating so that at some point they may, in the interim, go ahead and settle the matter. Probably that is the intention with which they do that. But ultimately, the Supreme Court had clearly upheld the entire content of the plan. There has been absolutely no relief provided by any of the appeals filed by the promoters. So it has been completely dismissed and disposed as well in various issues. And there are certain issues raised by the operational creditors and all that has also been taken care of as part of this order. But more importantly, one issue which I wanted to discuss in this case, or rather two issues, was one raised by the board of directors, which is in the case which is where they relied on the case of Mr. Vijay Kumar Iyer, in the case of Vijay Kumar Jain, wherein they were of the opinion that the board of directors should receive a copy of the resolution plan. Okay, so the directors, the erstwhile promoters' stand is that they haven't received a copy of the resolution plan, and they relied on the case of Vijay Kumar Jain versus Standard Chartered and Standard Chartered Bank to say that they are entitled to receive the resolution plans. However, the Supreme Court noted that, firstly, it is the RBI who has superseded the board, and they appointed the administrator. So, and further, the ex-directors, by virtue of this act, the ex-directors are deemed to have vacated their office. Right. So this is an extremely interesting fact, interesting aspect, that because it's a financial service provider and the RBI has superseded the board of directors, so therefore the ex-directors are deemed to have vacated their offices. So in such a case, you cannot expect the RP to keep, comforting the ex-directors with whatever information they need. Second, in this case also, they were actually in judicial custody all throughout the CARP process. They were arrested. So where come the administrator has even the opportunity to provide such kind of a plan to them? So therefore, Supreme Court held that where the directors having deemed to have vacated their offices on the supersession of the board, they should not have ideally claimed any right. They do not have any right to attend the meetings at all, not to participate in the CARP proceedings, right? Which would otherwise be available for any director suspended under the IBC. So that was one interesting aspect which was dealt with this. But more importantly, what you can see on the screen was with respect to Section 66 recoveries. Now, what is all about the Section 66 recoveries? Let's try to understand. So basically, what happens in this case? What is proposed as part of the resolution plan of PRAKUL Capital and Housing Finance is that they said that all the recoveries made from the avoidance applications filed under Section 43, 45, and 50, right? All those proceeds should be appropriated in favor of COC, right? Whereas there is a Section 66 petition also pending against which is a fraudulent petition pending against the erstwhile promoters, for which Piramal said that those proceedings has to belong to the RA, that is Piramal. And this was duly agreed by the COC. So the COC had duly agreed for this, and after the agreement of the COC only, this, of course, the clause was approved by the COC, and subsequently it went ahead to the NCLT. So at the NCLT level also, there was a question on this as to they will need. I mean, there was a question on this particular aspect that the Section 66 proceeds cannot belong to the RA because they have provided an extremely low notional value of 1 rupees to the Section 66 applications. So therefore, this cannot be considered. This is not a valid point to be considered as part of the resolution plans, right? So that was what was technically provided. I mean, technically alleged in the NCLT level. But NCLT said, boss, see, this is a commercial decision already agreed between the parties. We can't do much about it. Then they went ahead before the NCLAT, right? So when they went ahead before the NCLAT had basically made some level of alteration to this clause. They basically gave some direction for alteration of this clause, which was found to be in violation of the commercial wisdom of the COC. So that point was raised by the successful resolution applicant, was challenged by the successful resolution applicant before the Supreme Court, right? So now that is where the Supreme Court stepped in, and if you can see this observation which I have highlighted in italics. So wherein Supreme Court says that when majority of creditors, in their wisdom and after negotiations with the PRA as to how and in what manner the CARP should be undertaken, had explored the feasibility and viability while approving the same. And when the plan was also approved by the NCLT, NCLAT ought not to have tinkered with a clause of the plan with regard to treatment of recoveries from applications under Section 66 of IBC. So the reason why I find this clause more interesting is that, at least from my personal experience, when we move to the NCLT for filing of our applications for approval of a plan, and the kind of questions, I wish if other RPs may also share your personal experiences here, the kind of questions we get from the NCLT are quite unexpected in all the cases. Even though the law envisages the NCLT to strictly look at Section 30, subsection 2, the mandatory contents, then go ahead and approve the plan within 14 days, that is what was envisaged. But unfortunately, the kind of questions we have from the NCLT go beyond this, wherein they ask what's happening with the avoidance application. Why is it filed? Why is it not filed? Where is the transaction audit report? What's happening with the unit? What is the operation status of this particular company? And in one of my matters recently, I was asked to even provide the photographs of the status of the real estate project. And because of which the case was postponed to another hearing. So ultimately, what I'm trying to say here is there are certain things called commercial elements for which COC is the whole and sole authority. Though not a judicial authority, but COC is the whole and sole commercial authority to decide on that. There is no way any judicial intervention shall go where commercial wisdom of COC is involved. The COC, the very role of NCLT is only to see whether the mandatory contents of the plan are there, and for which RP is the one who has been given the responsibility to provide a diligence report. That's all. Beyond that, if NCLT is going in terms of in questioning the commercial wisdom, this is how the litigations go on forever. So you might have remembered DHFL plan some way back in 2019-20 is when this got approved. Whereas we are in 2025, the litigations, I mean, just imagine a litigation carried on for 5 years. What amount of cost would have gone in for the both the parties to, or even for the RA, what amount of money would have been involved in litigating this particular case? While it is extremely clear that a plan which was devised with with after negotiations with the COC, approved by the COC, if NCLAT comes in and tries to alter the effect of these kind of clauses, then it is going to have a direct impact on the implementation of the plan, right? So that's exactly where the Supreme Court had stepped in, saying that this is not something which the NCLAT should have poked its nose into. So therefore, this tinkering of a clause cannot be encouraged by, it cannot be encouraged, and therefore, whatever has been provided as part of the original plan shall continue, is what was provided for. And further to that, it also gave a direction that the NCLT should decide these applications and pass the orders under these sections 44 to 51 and 66 independently, because this is, probably this is the first time where section 26 of the IBC has come into picture, where the Supreme Court had also clarified again, saying that section 26 is very clear that any pending any filing of avoidance application should not affect the proceedings of CIRP. So that was what was provided in section 26. So therefore, in such a case, why should it have any impact on the plan as such? So the avoidance application has to go parallelly, and whatever recovery comes, that's something which the plan has already addressed. So therefore, there was absolutely no need for either NCLT or NCLAT to have commented anything. And since NCLAT had interfered in this particular clause, so that was held to be completely transgressing the jurisdiction under section 61 of the IBC. This is the exact words from the Honorable Supreme Court. So this is with respect to this particular case, wherein the Supreme Court had held that the clauses under the plan which were approved by the COC with their commercial wisdom cannot be altered by the NCLAT, or of course by the NCLT as well. And they also to summarize, it also says that the judicial review should be narrowed down to sections 30 and 31, which I was commenting, which was nothing but the mandatory contents of the plan and the procedural aspects of the approval. And there cannot be a situation where they can substitute their judgment for the COC's business decision making. And I think we all know case Ashidhar matter, even Ganesham Mishra. In many matters, the commercial wisdom of the COC has been upheld from time to time. This also now gets added to the list of cases which provide for or which uphold the commercial wisdom of the COC. So yeah, we will now move forward with the other matter. Okay. The next matter is with respect to Visa Coke Limited versus Mesco Kalinga Steel Limited. Now again, this is a matter where there is a demand notice which was served under Section 8. Right? So demand notice was served under Section 8 as part of the requirements for an operational creditor to initiate a CIRP litigation under IBC. So, demand notice was issued by the operational creditor, and here again a simple question, but a very practical issue which we face is with respect to the registered office and the service of this notice, right? So for that, let us first maybe just go back into the facts, right? So as per section 8, there is a term used, deliver. Okay, so it basically says where there is a default, you need to deliver a demand notice, either in, of course, that form 3, form 4, whatever format, it has to be delivered, right, to the operational creditor. So now the question is, if this notice was delivered to the registered office, okay, firstly, it remains very clear that it is registered to the registered office, but through its, like, of course, the name was of the director, CFO, and other manager, commercials, etc. So whether such a notice which was delivered on the KMPs but at the registered office of the company, will that be considered as a valid notice or not, is the basic question, right? So I mean, you may find it extremely silly, but that is exactly the litigation which went ahead even till the Supreme Court to question whether this is correct. Can you address the demand notice on the KMP of the entity and not the entity itself? Can that be considered as a valid service, is what is the question, right? So for which, of course, it ended up before the Supreme Court, and then Supreme Court basically again stated that, okay, I mean, ultimately you are trying to come down on certain hyper-technical issues like that of delivering of a notice and the address to whom it is being addressed and all. But what is more important is with respect to the understanding of what should be the content of a notice and what should be the what should be the format in which the demand notice has to be sent, etc. Right? So ultimately, if the basic if the basic requirement under the law is met, then these kind of hyper-technical defects should not ideally be looked into, which unfortunately both NCLT and NCLAT had looked into. So in this case, both NCLT and NCLAT had rejected the Section 9 petition on this ground alone. So that's where the Supreme Court said these kind of rejection needs or deserves interference by the Supreme Court, and they allowed the appeal, and they set aside the orders of NCLT and NCLAT, and they remanded the matter back to the NCLT to entertain the Section 9 petition afresh. So this was the case. So see, the whole idea was that whether such kind of a service of a document to a KMP of a company, is it a valid service of the document, which is the notice under Section 8 or not, was the challenge, right? So the whole point in which the Supreme Court had directed this discussion was saying that the KMP was acting not in their personal capacity, but on the official capacity as an official position on behalf of the corporate debtor, right? So therefore, the notice was not served to the KMP on their personal capacity, but on their official capacity on behalf of the corporate debtor, which would technically mean that it is as good as the same was issued to the corporate debtor and not to the KMP on their personal capacity, right? So again, they went ahead to say that the Supreme Court went on to comment that the respondent company, which is Mesco Kalinga Steel, had never objected the fact that notice was not served upon them, right? So they were rather pointing out of the fact that the notice was served onto the KMP of the CD, right? Which is a very silly point to rely on, but unfortunately they got the orders in their favor, both in the NCLT as well as in the NCLAT. That's why obviously it has ended up in the before the Supreme Court, right? So therefore, ultimately, what Supreme Court had prioritized was whatever notice was made, which was rightfully sent to the registered office addressing the KMP, should be construed as a deemed service of demand notice as required under Section 8. Right? Accordingly, they held that the notice cannot be taken. I mean, accordingly, they held that this kind of a technical ground is incorrect and unsustainable. Right? These are the exact words from the Supreme Court's order. So then, of course, the other aspects of default, existence of default and all will come into picture, obviously. So that is something which is going to be dealt with subsequently by the NCLT. But the core concern or a very extremely technical ground based on which NCLT and NCLAT had, in fact, went ahead to reject such kind of an application was, I think the Supreme Court also commented that to be extremely technical, which should not ideally have been done by the NCLT and the NCLAT. So yeah, so this is something which was there, and unfortunate. I mean, like quite interestingly, in fact, NCLAT Delhi itself, in one of its order, had ruled that whenever a notice is served on a director of the CD, it should be deemed delivery, or rather, it should be a good service on the company, was what was held by the NCLAT itself, right? But still, the NCLAT in this particular case has went ahead to dismiss the Section 9 petition. So that's the whole issue in this particular case. So therefore, wherever a notice has been served to a KMP or a director of the company at the registered office of the company under Section 8, it is a good service of notice, and accordingly, it cannot be held to be unsustainable, or it cannot be held to be improper. That is one. Second, as a matter of suggestion for all of us as RPs who are advising various clients to issue notices under Section 8, it is always preferable to issue a notice separately on the name of the company, then to each of the directors and KMPs on the MCA portal, but all of it is addressed only at the registered office of the company. And even at and all the details, everything has to be, of course, obviously of the company. But even since these kind of litigations are also prevailing, it's always better to ensure we are not getting occupied with this kind of unnecessary litigations, because see what kind of impact this has. This can also impact the question of limitation as well. So we need to be extremely careful whenever we are issuing a notice under Section 8 to ensure that it is adequately served in accordance with law. So now we will move ahead with the next order, which is with respect to in the matter of Tata Steel Limited versus Rajkumar Banerjee. Now again, this is another interesting aspect wherein the Supreme Court had considered the case of limitation whenever an appeal is filed before the Honorable NCLAT. Now, we all are aware that in the case of appeal before the Honorable NCLAT, like usually the appeals we find before the Honorable NCLAT are passed under section, usually passed against the resolution plan orders. Now, the IBC is extremely careful in terms of the limitation period offered to the Honorable NCLAT. Now, what does it say? It says that you need to file the appeal within 30 days. If you fail to do so, then within next 15 days, with of course the delay of that with additional 15 days of grace period, which the NCLAT can condone. But beyond 45 days, there is nothing provided in the law enabling anyone to file an appeal, right? So if I have to read this for the interest of everyone, it says that ideally every appeal should be filed within 30 days, but provided that the NCLAT may allow an appeal to be filed after the expiry of the said period of 30 days, if it is satisfied that there was sufficient cause for not filing the appeal, but such period shall not exceed 15 days. So if there is a sufficient cause for you to not file an appeal within 30 days, then NCLAT has a power to condone this delay, but not exceeding a period of 15 days. thereby meaning that the maximum total permissible period under section 61 of IBC is 45 days, which comprises of 30 days is a prescribed period, limitation period, and additional 15 days which can be condoned upon showing sufficient cause, right? So therefore, it very clearly says that whenever NCLT pronounces the order, that is the date on which you will the limitation period will trigger, right? So within 45 days thereof, you are supposed to file an appeal, and irrespective of what kind of ground you may have, the statutory maximum period of 45 days shall remain the same, and you cannot exceed the 45 days, and even Honorable NCLAT will not have any power to condone the delay which was delay in filing of the appeal beyond the statutory period of 45 days. So this was what was observed by the Honorable Supreme Court in this case. So where it very clearly says NCLAT has no power to condone delay beyond the period stipulated under the statute. And of course, it goes on to comment that allowing such a condonation would defeat the legislative intent and open the floodgates to belated and potentially frivolous petitions, thereby undermining the efficacy and finality of the appellate mechanism, which is obviously, in my opinion, a very relevant ruling. And in fact, the Supreme Court itself, in the case of Kalpraj Dharamshi versus Kotak Investment Advisors, also held that NCLAT cannot condone any delay beyond 15 days, even on equitable grounds, right? So that the case was also being referred by the Supreme Court in this particular situation, and had opined that there is this kind of a condonation of a delay beyond 45 days cannot be entertained by the NCLAT. And it's an interesting case. I mean, you can see there are a lot of orders which are provided for in terms of limitation period, in even interpreting what happens if the date of filing falls on a court holiday, then what has to be done, and all these aspects were also being provided for. And the limitation, of course, as I said, the limit they have went ahead to interpret how this period of 45 days has to be provided for, and how if the limitation is ending on a Sunday, how the next working day, that is the Monday or maybe the next working day, can also be permitted to be included in the prescribed period of 45 days, was what was provided for in that particular case. But of course, the ultimatum in this case is that Supreme Court cannot or should not have allowed any condonation of delay in filing of appeal beyond the 45 days period. So that is again very important for us, that whenever any aggrieved party is filing an appeal, they should ensure that they are immediately moving to the Supreme Court and not by waiting for this entire expiry of 45 days period. So that's about it. And then yeah, but again, just one interesting aspect, probably a practical aspect for all of us to know in this case, is that generally what happens is, as per the Supreme Court order, now the limitation should start from the pronouncement date and not from the date you receive the order. That is very clearly laid out in the Supreme Court. But of course, the Supreme Court also clarifies that there is a rule of the NCLAT rules, Rule 22, which mandate filing of a certified copy along with the appeal. So they say that the limitation period is not contingent upon the receipt of such a copy. So the limitation period cannot be contingent upon receipt of such a copy. However, if an appellant applies for a certified copy, the time taken to obtain such certified copy can be excluded from the limitation period. So therefore, there is a need for parties to apply. I mean, see, wherever you're applying for certified copy, then the time taken by the NCLAT or by the NCLT in giving that certified copy can be excluded from the limitation period. But that cannot be a ground for extending the limitation period. So we need to be very careful whenever we are making such an applications before the NCLAT. But ultimately, what we need to learn from this is that whenever there is any NCLT order, whenever we are making an appeal against this NCLT order, we need to be extremely careful on the front that what is the time limit within which we are filing this appeal. So we should not exceed the condonable period of 15 days, by which there is a great chance, or rather complete rejection of our appeal, and we will not have any other forum to go and litigate this particular case. Of course, you may say I will go and file a writ, but not many high courts are entertaining anything, and particularly on a plan, I am extremely sure that you will not have any stand to withhold filing of a writ or anything, because currently there is no such provision of a plan which can be challenged constitutionally by any private party also. So that's the more important aspect, and in my view it's a very good clarification which we got as part of this year's jurisprudence under the IBC. Okay. The next is in the matter of Saranga Anil Kumar Agarwal versus Bhavesh Dheerajlal Shah. So this is a case dealing with Section 96 moratorium. Again, an interesting aspect which we need to understand with respect to the jurisprudence of personal insolvency. So till now, I think what all orders we were looking for are majorly focusing on CARP aspects and jurisprudence of IBC under the CARP. But this matter of Saranga Anil Kumar Agarwal pertains to a 96 moratorium. Now, let us understand what this 96 moratorium is all about. So, as per Section 96, there is an interim moratorium, right? It is not this position of interim moratorium is not there as part of CARP or of course in liquidation we do have a moratorium as such, but this interim moratorium per se is not available for a CARP case. Now, what is this interim moratorium? See, interim moratorium is a situation wherein when an application has been filed by a personal guarantor under Section 94 or by a creditor under Section 95, from the date of filing, an interim moratorium will come into picture under Section 96, by which any pending legal action or proceeding in respect of any debt against the personal guarantor shall be deemed to have been stayed. And further, the creditors should not initiate any legal actions or proceedings in respect of any debt. But the debtors are free to do so. Ideally, at least as per my interpretation, under Section 96, there is no bar against the personal guarantor from taking any action. So now comes the question. Under Section 96, this moratorium which says any pending legal action or proceeding in respect of any debt shall be deemed to have been stayed. This is the major point of contention of the parties, right? So where the question is, there is a consumer, there is an execution proceeding EP pending before the consumer court, and this EP execution petition under Section 27 of the Consumer Protection Act, whether this should also be stayed as an effect of the interim moratorium granted under Section 96 of IBC, was the moot question before the Supreme Court, right? So does this also apply on the recovery proceedings, particularly by the NCDRC, National Consumer Dispute Resolution Commission, or not, was the major challenge. So the long story short, the answer the Supreme Court has provided was that it cannot be considered as a debt or a proceeding for debt, because this is a proceeding provided for. So, these are treated as non-debts rather, right? These penalties are not considered as debt. So therefore, you cannot impose the interim moratorium for a particular penalty imposed by NCDRC, which are regulatory in nature and which do not constitute debt. So therefore, such proceedings cannot be stayed, was what the Supreme Court has very carefully interpreted and concluded. And this line is important, which says the moratorium under Section 96 does not extend to regulatory penalties imposed for non-compliance with consumer protection laws. So any regulatory penalties imposed for non-compliance with consumer protection laws are not debts. And whereas Section 96 only provides for interim moratorium for any actions or any prosecutions in respect of a debt which will be deemed to have been stayed. Whereas a punitive consumer penalty is not a debt. So it cannot, the interim moratorium cannot extend towards such debts, and such directors or personal guarantors are liable to make the payments and cannot take the shelter of interim moratorium under Section 96 was what was laid down by the Supreme Court. So, of course, in order to come to this conclusion, the Supreme Court had, interpreted various issues with respect to how a proceeding of NCDRC differentiates from a debt proceeding. And then they also came up with conclusions saying that the penalties which were imposed by the NCDRC are majorly arising due to non-compliance with consumer protection laws, and accordingly they serve a regulatory function rather than constituting debt recovery proceedings. The Supreme Court's opinion or Supreme Court's observation is that the proceedings before NCDRC are not debt recovery proceedings, while the interim moratorium under Section 96 of the IBC is to stay all debt recovery proceedings. Therefore, this distinction is very clear, and hence you cannot consider a stay on proceedings before the NCDRC was what was provided for in this particular case. And and then, of course, there was one interesting differentiation which was, raised, of course, by the appellant, wherein they were questioning on the stay imposed on, the check dishonor matters, right? So there was a case. I mean, there was a argument by the appellant stating that a check dishonor matter is stayed because of a 96 moratorium. In fact, under Section 14 moratorium also. So why should it not apply equally for a NCDRC petition was what was, fundamentally deliberated by the appellant. So now that is where the Supreme Court went ahead to dispute, saying that firstly, Section 38 is a criminal proceeding, and not just that it is a criminal proceeding, but more importantly, it is a proceeding which is emanating out of a failure to honor financial obligations. So therefore, the proceedings are where the proceedings are initiated for the question of financial obligations. Paying them is a different aspect, but where the proceedings under NCDRC do not assume or do not go into the question of any financial debt. They are only concerned about deficiency in service. So in such a situation, the jurisdiction of NCDRC cannot be limited, and there is no meaning in drawing an analogy between the moratorium with respect to Section 138 of Negotiable Instruments Act and Section 27 of Consumer Protection Act is what was held by the Supreme Court. And ultimately, Supreme Court clarified that this is not a debt recovery proceeding. So therefore, there cannot be any stay granted for such proceedings against the against the NCDRC proceedings or the penalties imposed, which are regulatory in nature. So this is again an interesting ruling, considering the fact that many personal guarantors are filing applications under Section 94 who claim protection of interim moratorium under Section 96. I think it is high time for them to realize that this interim moratorium is only to shield them from actions against them for any debt recovery, and it has nothing to do with any penalties imposed by regulatory bodies or other deficiency in services, etc., which has nothing to do with the debt recovery mechanism, for which there is no stay. Having said this, of course, it's an order passed way back in March, but considering the IBC bill which was introduced before, which was introduced in the parliament and earlier, which was under deliberations, one point is clear that this section 96 is going to be lifted. At least that was the proposal. They do not want any interim moratorium because I think it did reach the regulator that this section is being misused. More importantly, by way of filing section 94 petitions so that they are getting more room to start troubling the creditor. So therefore, I think that's the whole reason why the section 96 is supposed to be repealed in the amendment. So we have to see how this will be received and how this will be deliberated on and what. Of course, recently in the report of the committee, I could not find anything on this. So probably it must be continued as is. But again, it's a very interesting fact that when the regulator is very clearly observing these kind of misuse of provisions by the person director. And but just my personal view on this is that ideally this part 3 pertaining to insolvency resolution for personal guarantors, pertaining to insolvency resolutions of individuals was never framed or was never even deliberated from the context of a personal guarantor. It was, in my opinion, it was an afterthought. Because there were many litigations against personal guarantors, I think it was an afterthought to use these provisions for personal guarantors, but these are really not drafted for the personal guarantors or to address the situation of personal guarantors. Probably that is one of the reasons why we see. Okay. This is all about this R. Anil Kumar Agarwal matter. We'll now jump ahead to last two cases. The next case is with respect to you see on the screen, Viva Google and another versus Commissioner of Income Tax, Deputy Income Tax. Sorry, I think.
So again, you are not
Supreme Court
audible,
versus-
sir.
Sir, again, your voice not coming, sir.
Is it now, sir? Or
No, nothing coming, sir. Nothing coming. It is very, very disturbed.
since how much
Broker.
time?
You're not audible, sir.
Any better now?
No, sir.
No, sir.
But since when are you facing this problem, sir?
Now
Last
again
few
for
minutes,
last 6,
2,
7
3
minutes.
minutes.
I'm facing for 6, 7 minutes. Earlier 10 minutes before it was coming, and then before that also not coming.
You have just told me immediately. Just a minute, sir. I'll try and run it.
Ji.
Yeah. Is it better, sir?
Yes, sir. It's little better.
Okay. Okay. Thank you. Thank you.
Now
I
it's
just
good.
changed. Yeah. 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 Thanks. I'll just. Okay. So the next case is Vaibhav Goel versus Deputy Commissioner of Income Tax. So I was just explaining that this is a case where, one second, just resound off my own voice. Sorry, I'm just getting resound, so I'm just addressing that. Yeah, perfect. Sorry. Yeah. So this again, Vaibhav Goel matter. This is with respect to the past dues which the supreme sorry which the income tax authorities usually come up with when in terms of old I mean unclaimed statutory dues which were not claimed as part of the resolution plan. But again, this is usually common. I agree, and there are various matters. Even Gansham Mishra addressed this. But now, the more importantly, this case was because this was claimed against the guarantors, right? So this is again like the promoters of the company have come forward on these kind of issues with respect to pre-CARP taxes, asking them to make the payments because the company is now under CA, I mean, as closed under CARP. So therefore, they demanded the promoters to make the payment of those taxes. So the question, the prima facie question which is posed before us is that once a CARP is, I mean, once a resolution plan has been approved approved by the NCLT, and subsequently, if the income tax authority comes against the resolution applicant, we know that there is a it's considered as a hydra head popping, and it is against the principle of clean slate. So therefore, such claims cannot be against the resolution applicant, who should not be troubled with the new claims. But here, this is an interesting case where the demand was against the appellant, that is the promoters, and I'm sorry. Again, this is the demand was made against the corporate debtor, and this is purely for a assessment year which was way beyond in the past, which was almost 2011, 12, 12, 13 was the assessment year, pursuant to which now they are coming up with demands against the company. So this was basically considered as uh, a violation of clean slate principle, which was provided for in multiple matters. So in this case, fundamentally what happened was, in fact, the income tax authority has never the claim submitted by the income tax authorities was provided as a contingent liability, and that contingent liability for was for with respect to the assessment year 2014-15, right? But subsequently there was no such reference to the liabilities for the years 2012-13 and 2013-14, because those were never shown as contingent liabilities in the resolution plan. So maybe even in the IM, those never would have been shown as the contingent liabilities. So in such a situation, if income tax authority at a later stage comes ahead and says, boss, see, we have now done with the assessments for these 2 years. Now these are the dues which you are supposed to pay. Should it be allowed is the fundamental question, right? So where the Supreme Court, again, it's another feather in the cap where Supreme Court very clearly says that once a plan is approved, it is binding on all, including the central government. And if a statutory due owed to such a central government is not part of a plan, it shall stand extinguished, number one. And more importantly, no proceedings could be continued in respect of such dues for the period prior to the date on which the resolution plan is granted. So one is the proceedings are extinguished, sorry, the existing debt is extinguished, rather the claim is extinguished. And second, you cannot continue any past proceedings at all once the plan is approved, right? So therefore, that is again that was something which was very clearly provided for by the Supreme Court. And uh, unfortunately, in this case, the NCLAT had entertained the case of income tax of this ruling, wherein they gave a adverse order against the resolution applicants. So therefore, they basically went. I mean, the Supreme Court opined that NCLAT even have not considered the decision made by the Supreme Court way back in Ghanshyam Mishra. In fact, Ghanshyam Mishra was the first to, I mean, was one major order wherein it very clearly addressed that you cannot come up with the post-dated claims. All claims which are not part of the plan are deemed to have been extinguished. That position is extremely clear. And apart from that, also there are certain orders where Supreme Court had clarified that position. But Ghanshyam Mishra is one of the major orders which even today all lawyers refer to as part of their you know orders, right? So as part of their arguments. So after even Ghanshyam Mishra, if NCLAT is passing such an order, so it is quite an unfortunate state of affairs for us to be in, right? So just imagine if the resolution applicant, we advise the resolution applicant, and subsequently this kind of litigation comes up, and they spend a lot of money only to come to a point which is already settled by law. I mean, like how uncertain this can be on investors is something which always troubles me, particularly in this kind of a litigation, which were like, I see these kind of income tax orders coming time and again. So there is absolutely no um, um uh, sorry, yeah. Sorry. Yeah. So there's absolutely no way NCLAT should have even entertained such a additional demand coming for a past period, and therefore, ideally, the Supreme Court had ruled out this particular case, and they have approved of. They very clearly stated that there cannot be any such fresh proceedings against the CD. Actually, there in my presentation, I will make the change. It is not against the personal guarantors. I think I instead of corporate, sorry, resolution applicants, I mistakenly has written it as personal guarantors. My bad for that. So yeah, so you cannot have a proceed. I mean, there cannot be fresh proceedings against a resolution applicant for past income tax dues. Is what exactly this case is all about, and which again, as I said, it is already dealt with in Ghanshyam Mishra matter. The same is also now upheld in this case. So yes, now just one order from the NCLAT, which I thought maybe we should have a brief discussion on, is with respect to again a very technical issue, which is in terms of the authority in a Section 7 petition. Again, this is a pure technical issue where NCLAT had clarified that if there is an authority given by way of designation and not by name, meaning, let's say a bank, see, we all know how banks operate, right? As financial creditors, the banks, they have multiple, uh, uh, you know, yeah. So as financial creditors, particularly banks have multiple teams operating on multiple cases, and it is not like a private limited company where you can simply arrange a resolution, or to any particular officer. It is a time-taken process, procedures. The board of directors are different. The board meets at regular intervals and all that, right? So in such a situation, a bank had in this case, Indian Bank, they have authorized they basically authorized a designation, not a name. Okay. They came up, I mean, they authorized a designation of a particular person, like someone holding the position of a CMD or executive director has been authorized to nominate individuals for issuance of power of attorneys, and the nomination was by office designation. That is saying that any general manager, AGM of so and so. So see, the positions change, right? The individuals change. So therefore, they have given authorization for a particular position. Now that has been challenged. saying that the one who is initiating this petition has not got sufficient authorization for filing it. Again, just like how we have seen the Section 8 order, this is also kind of a hyper-technical issue. This is absolutely nothing to do with the debt default, nothing. It was only in the position that there is no specific name provided for, right? So on this ground, the NCLT has rejected this petition of Section 7. Can you just can you imagine that there is a this was dismissed uh, uh, by the NCLT without going into the merits, purely on the maintainability, saying that the officer who has filed this is not having a validly executed power of attorney. Okay, so that is exactly the issue. As to the one who executed the power of attorney, whether they have the authority to execute the power of attorney or not was the major challenge before the Supreme Court. So that's where they have gone through the board of directors resolution, where the board fundamentally authorized two of them, that is their CEO, and they have also two general managers and executive officers or assistant general AGMs and DGMs. So that way they have given the designation for the ultimate authorized power of attorneys, and such a power of attorney can be given or nominated by the chairman and managing director, or in the absence of chairman and managing director by an ED. This was the resolution. So fundamentally, what happened? The NCLT had interpreted to mean that the power of attorney holder, the one who is giving the power of attorney, does not have a authority to issue power of attorney because the board resolution does not mention their name. Can you imagine? This is one of the grounds on which NCLT has dismissed this entire petition of Section 7 filed by Indian Bank. And obviously, Indian Bank went before the NCLAT, did not get a relief before NCLAT. They ended up before they came before the NCLAT, where the NCLAT had had basically ruled that the NCLT is wrong in its order to dismiss this matter on maintainability, because the power of attorney is validly executed, and they categorically held that the nomination of the board to nominate a chairman of the bank or the MD as a position is also a sufficient authorization to issue power of attorney. A mentioning of a name need not necessarily be a valid prerequisite for providing any authorization. So this is again, of course, not much to do with the IBC part, but I felt again one aspect that how NCLTs can start making uh, a huge issue out of a very simple procedural and technical challenge, right? So this is by NCLT Principal Bench, New Delhi. This order was passed by them in March, and in August, this ruling has come from NCLAT. So that this is all about it. I tried capturing 10 major orders, 9 from the Supreme Court, one from the Honorable NCLAT. I'd be more interested, or maybe if any of you have experienced or come across other orders you would like to discuss, or if any of you have any questions on whatever we discussed so far, I'd be more than happy to take up the questions. So I'll be anyways sharing this presentation, the modified one. But yeah, otherwise, if anyone has any follow-up questions or wanted to add anything to whatever cases I've discussed, I'll be more than happy to hear you out. So
It was a great session. It was a
Yes,
great session. Learned a lot of nuances, and few of the judgments which we have read, they
sir.
got in a way it was a revision for us. So thank you very much, sir, for
Thank
updating
you so
us
much. Yeah.
and compiling it for the benefit of all.
Yes, sir. Thank you, sir. I'm very happy I've
Thank
got an active audiences. Like when my mic was off and somebody was pointing out, it was actually very relieving because that assures that everyone is listening to what has been
Yes,
discussed.
sir.
So thank you so much for that.
Thank you, sir. Thank you.
Yeah. Yeah. And any follow-up questions by anybody, or Anjali ji, you can sum it up and conclude the session.
Thank you, sir.
Yeah. Thank you, ma'am. Thank you so much, sir. Anjali ma'am.
Sir, I request you to call her. She may be busy with some
Yeah,
other work.
I'm doing it, sir. Yes, yes, yes. I just want her confirmation.
Sir, shall we conclude?
Yes, yes, ma'am. Yes, ma'am. Thank you. I mean,
Okay. Thank you
I
very much, sir.
completed.
Thank you all the
Yeah.
participants for giving your valuable time. Uh, sir, you are requested to share a presentation of the workshop, please.
Yes, yes, ma'am. I'll do it right away.
And now the first session, which was not held today, will be going to held on 31st of December from 10 to 1 p.m.
Link you will be sharing.
Yes, I will share the link again. वैसे तो same link will be there.
ठीक है, ma'am. Thank you. Thank you, sir. Thank you, ma'am.
Thank you. Thank you. Thanks, everyone. Thank you.
Thank you, ma'am.
Thank you.